Good morning, ladies and gentlemen. Thank you for allocating your time to listen to our panel discussion on the topic of medical negligence today. My name is Yap Jia Cheng and I am your moderator for today. Based on our topic, we have invited 3 guests to tell us more on our topic. Firstly, I would like to introduce Ms. Winnie Chong, a well-experienced practicing lawyer who specializes in medical negligence litigation, Ms. Lim Yixuan, a victim of medical negligence, and Ms. Angeline Lior, the president of the Malaysian Medical Association. The medical profession is considered a noble profession because it helps in preserving life. We believe life is God-given. Thus, a doctor figures in the scheme of God as he stands to carry out his command. A patient generally approaches a doctor or hospitals based on its reputation. Expectations of a patient are twofold. Firstly, doctors and hospitals are expected to provide medical treatment with all the knowledge and skill at their command, and secondly, they will not do anything to harm the patients in any manner, either because of their negligence, carelessness, or reckless attitude of their staff. Though a doctor may not be in a position to save his patient's life at all times, he is expected to use his special knowledge and skill in the most appropriate manner, keeping in mind the interest of the patient who has entrusted his life to him. Therefore, it is expected that a doctor carry out necessary investigations or seek a report from the patient. Failure of a doctor and hospital to discharge the obligation is essentially a tortious liability. Although at present, Malaysia is not experiencing the kind of malpractice crisis as in the United States, Australia, and the United Kingdom. However, there is certainly a rise in the number of negligence claims and the size of awards. These factors are sufficient to cause alarm for future implications and generate serious thought to reform the present systems. Rising number of medical negligence claims is not considered healthy for a country, as it leads to a reduction for the amount of money available for patient care. A single large award can distort the amount government or private hospital can use to enhance healthcare. So without further ado, let's invite Ms. Winnie Chong to explain to us what medical negligence is.
So first of all, good morning to our most respected moderator, Mr. Yap, and fellow panelists that are present today. So let me introduce a little bit about myself. I'm Winnie Chong, a lawyer from Tun Razak & Co. I have been practicing in the area of medical negligence for 8 years, and today I'm here to discuss and give some advices with regards to medical negligence. So, to begin with, what is medical negligence? It is often used synonymously with medical malpractice, which means failure to act according to the accepted medical standard by a medical professional. So, now, what is negligence? Well, negligence is a common legal theory that comes into play when assessing who is at fault in a tort case. It is best to think that a tort case as a civil injury case. So, for example, if a driver fails to stop at a red light, then that driver is said to be negligent in the eyes of the law. So, similar to drivers, doctors and other medical professionals also have a duty to their patients to provide treatment that is in line with the medical standard of care. So, putting in a simpler way, medical negligence happens when the doctor's negligence treatment causes undue injury to the patient, or make the patient's condition worse, or causes unexpected complications.
I see. So now we have a clearer picture of what medical negligence is. So once again, thank you, Ms. Winnie. Next, Ms. Angeline, can you share with us your understanding on medical negligence?
Alright, thank you, our respected moderator, Mr. Yap. And good morning, I bid to fellow panelists, Ms. Winnie and also Ms. Yixuan. I'm Angeline and I'm from the Malaysian Medical Association, and on behalf of the association today, I'm here to discuss medical negligence. Well, generally, doctors in Malaysia are required to register under the association, and they are also regulated by the Code of Ethics. Recently also, the government released new Medical Regulations 2017, which will also regulate professionals. Well, medical negligence is the most common civil suit, I would say, against doctors. And in fact, a Harvard study was conducted, and it was found that 1 out of 100 patients were found to have actually actionable legal claims that based on medical negligence. However, to be found liable, the following factors must be present. Firstly, the defendant owes a duty of care to the plaintiff, and secondly, the defendant must exercise that duty of care and breach it, and thirdly, the plaintiff must suffer injury as a result of that breach, and fourthly, the conduct of the defendant must be the proximate cause of the plaintiff's loss or injury. Nevertheless, there are some patients who insist on filing suits even when doctors are not at fault. For example, when a family member dies, this loss may cause anger, and looking for a doctor seems like the right thing to do. After all, it seems like human nature to always look for a party at fault in any tragedy. This has brought numerous side effects to the medical practice. Firstly, the threat of lawsuits has caused doctors to engage in defensive medicine. What is defensive medicine? It is actually a practice where physicians order unnecessary tests or procedures just to ensure that in case of a lawsuit, they can claim that they have carried out reasonable duty of care. This causes the regular misuse of expensive technology, for example, CAT scans, just for simple headaches, thus a rise in healthcare costs. Many doctors also stated that they would avoid high-risk patients and high-risk procedures. This results in bad medical care. New procedures carry a higher risk of harm, and so doctors stick to conventional treatments, even in terminal cases, for fear that new treatment may hasten the patient's death. Also, courts tend to favor victims and run unrealistically high compensation in successful cases. This indirectly causes the rise in insurance costs for all doctors, and without doubt, the medical cost of patients also. Back to you, Mr. Moderator.
Okay, thank you, Miss Angeline. Next, Miss Lim Yishan, do you mind sharing with us your experience on medical negligence?
Sure. Hi, I'm Yishan, and I'm 21 years old, and I'm a victim who suffered injury in my left eye for 2 years, and at the advice of the doctor, I decided to do the surgery. It's a really hard decision for me, because what if my surgery fails? Will I be looked down by this society and considered as a disabled person? Will people think that I'm an alien and don't want to be my friends? Will people still love me? I've been floating with this question in my mind, but I have faith in my doctor to save my life so that I can take care of my family. The surgery was about 5.5 hours long, and for about 2 of those hours, I was awake. The doctor explained that the anesthesia is made up of 2 different elements. One is to paralyze the eye, and is to paralyze the body, the patient, and one is to put them to sleep. Unfortunately, the paralyzing agents worked on me only, and I was awake at the halfway, but I couldn't move at all. I was horrified to hear the surgeon listening to clubbing music throughout. Can you imagine where there's clubbing music playing through the surgery? Moreover, I heard things like cut deeper, pull harder. I was awake at the exact moment when they want to remove my eye. Eventually, the doctor realized that I was conscious, and they administered more of the nerve blocking anesthesia. At that moment, I feel like
being roasted on the barbecue pit. I was traumatized by the ordeal that I've been sleeping in a reclining chair since too afraid to lie down. In the end, the surgery failed and I lost my left eye. I suffer from post-surgery syndrome. My right eye will get pain and the trauma that I suffer keep on coming in my mind. I cannot live like a normal person anymore. When I suffer, I cannot do anything. I'm so lost now. I hope that the hospital can compensate on me. I couldn't work like a normal person now and I cannot support my family anymore. I hope for an apology from the doctor and I wish that the hospital to be responsible on this and compensate me with money allowance. Thank you.
So that was really a horrifying experience indeed. So thank you, Miss Lim. Alright, now let's throw the ball back to Miss Winnie. Miss Winnie, based on your understanding, what is the remedy that one can ask for through medical litigation?
First of all, I would say I felt very sorry for Miss Ishan's case. When talking about remedies, it is important to look at two elements, which is first, legal causation, and second, damages. It is really essential before a viable medical negligence lawsuit could even take place. For example, if the doctor's medical negligence was not a foreseeable result of the patient's injury, or the doctor's medical negligence actually had no detrimental effect on the patient's condition, then a medical malpractice claim will fall short and there will be no remedies. Usually the most common remedy that the victim can opt for is compensation for damages. For example, like loss of earnings, loss of future earnings, and pain and sufferings. Yeah.
I see. So therefore, victims of medical negligence can still seek for these remedies through bringing their case to the court. Many people say that medical negligence litigation has never been an easy process for both patients and doctors. So, Miss Angeline, what is your opinion on this statement?
Well, that is absolutely true because it is a tedious process for both patients and doctors as it can drag for a long number of years and cause loss of income for patients and also loss of reputation, income, and even the license for doctors.
Then, aside from bringing medical negligence claims to the court, what would be a better way for us to solve these disputes?
Well, in most cases, victims resort to mediation, and in your case, I think you could resort to that also. But the association thinks that for a win-win situation, it would be best to implement a no-fault scheme where both patients and doctors will benefit from it. A win-win solution would be for the government to actually introduce a no-fault insurance scheme to compensate patients while under medical care. This method would actually first quickly compensate patients who have suffered no matter how they suffered. Secondly, it also helps to encourage doctors to actually meet and expose the cause of the medical error. And thirdly, base a victim's economic cost for the medical treatment based on actual economic loss. And we wouldn't think that it would be such a difficulty to introduce this scheme, as it has been already introduced in countries such as Australia and some Scandinavian countries. So it would be our greatest hope to see this implemented.
Yeah, I do agree on having this no-fault system as a dispute resolution for medical negligence. Thank you once again, Ms. Angeline. Next, from what we know, it is actually hard for victim to actually win a medical negligence case in the court. So, Ms. Winnie, what do you think?
Well, it is definitely a lot of work to do to win a medical negligence lawsuit. In short, it is not easy to win a case as it depends on several factors which requires high standard of proof. So generally, there are like two tests to be applied when evaluating a medical negligence case, which is first the Bolam test and second the Whittaker test. So prior to year 2006, Malaysian courts only applied the Bolam test, which basically says that a doctor is not liable if his act or omission to the specific patients is generally accepted by ordinary medical professionals. However, after the years 2006, the court seems to be a little bit lenient and depart from the Bolam test and adopted the Whittaker test. So for the Whittaker test, the court held that a medical practitioner has a duty to disclose and warn a patient of any material risk inherent in a proposed treatment. The implication is that under the Whittaker test, the court will decide upon evaluating the evidence adduced. That is, the court will have the final say. So, the court will have the final say. So, whereas under the Bolam test, the court will defer to the opinion of medical professions. Also, the fact that the judges have difficulties in dealing with cases, struggle with technicalities which may be beyond the comprehension of the judge who has not undergone medical training. So, to reach a just and accurate decision, the matter is often left in the hands of the medical expert. Thus, the question of whether the doctor is in breach of his duty is to be judged by his peers.
So, is Bolam test still applicable in Malaysia?
Well, it is still applicable, but only to the case concerned to diagnosis and treatments, whereas to cases concerned to medical advices, Whittaker test will be adopted.
I see. Thank you, Ms. Winnie, for clarifying this to the audience. Next, let's ask Ms. Lim some questions. Ms. Lim, what do you think about the cost that will incur on the victim to bring medical negligence claim to the court?
Well, the largest cost for the medical malpractice lawsuits are usually fees for the lawyers and the fees for hospital for getting the reports. I need to pay much to get the medical reports again and again from the hospital. It took me a long time for the procedures in court and also my own personal report. The cause of my injury is hard to be identified as well.
So, in your opinion, do you think that a doctor should be discharged from his or her duty once proven liable for medical negligence in the court?
The answer is definitely yes. I think that a doctor should be discharged from the duty once proven liable for medical negligence, because everyone can only live once. If the doctor cannot take one's life seriously, I don't think he can be a good doctor. Before I end this, I would like to help all the victims who have suffered injury due to negligence to voice out. I literally hope that this issue should be magnified and the victims should be helped and not left out in this society. Thank you.
Thank you, Ms. Lim, for sharing with us your opinions on the issue of medical negligence. Ladies and gentlemen, we are at the end of this panel discussion. Thank you once again to all our guest speakers today, Ms. Andrea Liao, Ms. Winnie Chum, and Ms. Lim Nishan. Indeed, we cannot deny that medical negligence is an alarming issue happening around us today. We hope that the government can look into this issue and take some action to prevent this issue from happening. Till then, a very good day and thank you.